Your dog just bit the neighbor, and you're standing in the yard staring at the blood on the grass. Your stomach is in your throat. You're waiting for the police to pull up, wondering if your family pet is about to be taken away in a van, or if you're about to lose your house over a hospital bill. Take a deep breath. Panicking won't help, but understanding the playbook absolutely will. Let's walk through exactly how this works, step by step, using a real-world scenario. We're going to look at a case, see how it played out, and then pull out the general rules you need to know. Remember, this is education, not legal advice, because the exact rules change depending on where you live. Meet Mike. Mike works a standard factory job, and he has a fenced-in backyard with a locked gate. He owns a 70-pound mutt named Buster. Buster has never shown aggression to anyone. He's a couch potato who sleeps through football games. One Saturday afternoon, Mike is in the kitchen making lunch. He hears voices, and then he hears a scream. Mike runs outside. A 13-year-old kid from down the street is sitting on the grass inside Mike's fenced yard, holding his bleeding arm. Buster is standing a few feet away, looking nervous. The kid had climbed over the locked fence to retrieve a football he accidentally kicked over. The kid landed in the yard, startled Buster, and the dog reacted by biting the kid's forearm. The bite wasn't life-threatening, but it broke the skin, required an emergency room visit, stitches, and a round of antibiotics. The kid's parents were understandably furious. Within a few weeks, Mike received a massive letter in the mail from a local law firm. The parents had hired a personal injury attorney to go after Mike for the medical bills, the kid's pain and suffering, and their own stress. The letter demanded $50,000. Mike nearly fainted. He didn't have $50,000 in his bank account. He was terrified the court would order the sheriff to sell his house just to pay for the kid's emergency room stitches. He was also terrified animal control would show up to put Buster down. Mike's head was spinning with worst-case scenarios. So, what actually happened? How did the law treat Mike in this exact situation? The attorney's demand letter relied on a specific legal concept. It claimed Mike was strictly liable for the dog bite. Strict liability is a legal rule that says you're responsible for the harm caused, regardless of how careful you were, or whether you knew the animal was dangerous. In some places, the law is written so that if your dog breaks the skin of a person in a public place, or if they lawfully enter your private property, you're automatically on the hook for the medical bills. It doesn't matter if the dog is a golden retriever who has never growled before in his life. It doesn't matter if you're the most responsible pet owner on the block. However, that strict liability rule isn't the only rule on the books. Every state handles this differently, and many places use a completely different standard. A lot of jurisdictions rely on what is called the one-bite rule. The one-bite rule is a legal doctrine that generally says you're only held responsible for a dog bite if you knew, or should have known, that your dog had dangerous tendencies. Under this older rule, the injured person has to prove that your dog bit someone before, or that you knew the dog was aggressive. If your dog has a totally clean record, you might escape financial liability entirely. But under modern strict liability, a clean record doesn't save you from paying the medical bills. So, because Mike lived in a strict liability state, was he automatically forced to pay the full $50,000 demand? No. This is where another crucial legal concept kicked in to save Mike's financial life. The concept is called comparative negligence. Comparative negligence is a legal principle used to divide fault between the people involved in an accident, reducing the amount of money the injured person can collect if they were partly to blame for what happened. The law doesn't just look at the dog owner. The law looks at the actions of everyone involved. The teenager wasn't walking on a public sidewalk when he got bit. Your dog gets spooked by the fireworks, jumps on your friend, and knocks them into the fire pit. Your friend gets severe burns. They hire a lawyer. The lawyer sends you a letter. You can't just throw the letter in the trash because you think your friend is being dramatic. If you ignore the letter, the attorney will eventually file a formal lawsuit. Once a lawsuit is filed, the clock starts ticking on strict legal deadlines called statutes of limitations. A statute of limitations is the legally prescribed time limit you've to respond to a lawsuit or file a claim. If you miss the deadline, the court can enter a default judgment against you. A default judgment is a ruling where the judge automatically sides with the injured person simply because you failed to show up and defend yourself. If that happens, you lose your right to argue about who was at fault. When a letter arrives, your very first step is to notify your insurance company immediately. Call your agent. Tell them what happened. Tell them you received a letter. Give them the name and contact information of the attorney who sent it. If you have a valid policy, the insurance company is legally required to defend you. They'll assign a defense attorney to your case. A defense attorney is a lawyer hired and paid for by your insurance company to represent your interests, argue the facts, and fight to reduce the amount of money the injured person receives. The insurance company pays this lawyer, so you don't have to come out of pocket for legal fees. If you don't have insurance, that's the exact moment you need to go hire your own personal civil defense attorney. Don't try to negotiate with the injured person's attorney by yourself. Personal injury attorneys do this every single day. You don't. They'll eat you alive over the phone. They'll manipulate your words. They'll try to get you to admit that you knew the dog was dangerous. A local attorney knows the local judges, understands the local comparative negligence laws, and knows exactly how to push back against an inflated demand letter. You also need to cooperate fully with animal control if they show up at your door. Don't lie to the officers. Don't try to hide the dog. Provide them with your vaccination records immediately. If you hide the dog or if you lie about the incident, the city can hit you with criminal charges. Criminal charges are entirely separate from the medical bills and the civil lawsuit. Criminal charges mean the state is prosecuting you for breaking a local safety ordinance, which can result in massive fines, probation, or even jail time in extreme cases involving severe negligence. Keep your dog secured, follow the quarantine rules, and stay totally honest with the investigating officers. The legal system looks at every single detail of an incident. They'll look at whether you had a "Beware of Dog" sign posted on your gate. In some states, putting up that sign acts as a legal shield, proving you warned the public about the risk. In other states, putting up a "Beware of Dog" sign actually hurts you because it proves you knew the dog was dangerous before the bite ever happened. They'll look at whether the dog was on a leash. They'll look at whether the person who was bitten was running, screaming, or provoking the animal. Provocation is a legal defense arguing that the injured person intentionally or unintentionally did something to trigger the attack, like pulling the dog's tail or stepping on its paw. If the person provoked the dog, you're completely off the hook for the medical bills. Every tiny detail matters when the insurance adjuster is doing the math. The system is designed to figure out who bears the financial weight of an accident. If you're a responsible owner, your fence is secure, your dog is vaccinated, and the person who got hurt was doing something careless, the law provides you with massive shields to protect your savings account. You don't have to live in fear of losing everything just because an animal acted on pure instinct. If your dog got startled and nipped a friend who was visiting your living room, do you think the friend should be legally allowed to sue you for their entire hospital bill? Or should the friend accept responsibility for stepping on the dog's tail? Tell me your honest thoughts down in the comments. If this breakdown gave you the actual playbook for protecting your bank account when an accident happens, pass this video along to a buddy who worries about their lively pup every time someone walks up the driveway. Make sure you subscribe to Scribble Law so you always know the rules before an unexpected letter shows up in your mailbox.